Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this live content, and today will be the day I earn your subscription. For today's live stream, we've got a couple different stories I want to go over that will be of interest to people. We've got some updates on some prior stories, and then we have some things dealing with Jen Shaw, who wants to get access to protected information, attorney-client information, and filed a motion to that effect, and no. And then we've got this mandate thing from United Airlines that wanted all of its employees to have the jab, and the Fifth Circuit Court of Appeals appears to have reversed an injunction denial by the district court and sent it back for some further analysis. So we've got quite a few things to discuss today in law, but first I'd like to discuss very briefly Kyle Rittenhouse, who, as you will remember, was quite rightly acquitted of all the charges relating to the incident in Kenosha, because it was very clearly self-defense, as we could see ourselves from the videos. And then that initial information was confirmed from the witnesses who then testified about the things they saw. For example, I mean, the videos didn't show everything. For example, they didn't show Kyle being threatened earlier that day. If I get you alone, I'm going to kill you. That wasn't on video. So everything we learned from the witnesses only amplified Kyle's story of self-defense. And he was acquitted, as he should have been. And since then, people have been wondering, well, what's going to be next? So here is what he says at least is next, or what seems to be going on next. So he has announced a new initiative to fight media lies. And here's what he says so far. He's being a little bit vague and cagey about it, but here's what we know kind of so far. So in November, after the controversial trial, Rittenhouse was found not guilty on all charges relating to the shooting, in which he carried out with an assault rifle. Yes, that's true. That did happen. He has since emerged as a right-wing celebrity. He spoke to Tucker Carlson on Fox News. Me and my team have decided to launch the Media Accountability Project. Not great acronym, but you know. Rittenhouse said, as a tool to help fundraise and hold media accountable for the lies they say and deal with them in court. Carlson asked if, like the Covington Catholic kids, high schoolers from Kentucky, who came embroiled in controversy events on National Mall in Washington in 2019, you'll be suing news organizations that maliciously lie about people who are in the news? Yes, sir, we're going to hold people accountable. And then when asked if he had any particular ideas of who he might sue in mind, he said, well, right now we're looking at quite a few politicians, celebrities, athletes. Whoopi Goldberg is on the list. She called me a murderer after I was acquitted by a juror of my peers. Okay, and then Goldberg here, and this is going to be kind of interesting in terms of the defamation. Goldberg said the following: even all the excuses in the world doesn't change the fact that 3 people got shot. 2 people were murdered. To me, it's murder. I'm sorry. And then Rittenhouse also said, don't forget about Cenk Uygur from Young Turks. He called me a murderer before I was acquitted and continues to call me a murderer afterwards. And then I think Dave Schuster is quite correct here. Former MSNBC anchor, now with Young Turks, tweets, the courts have long established that calling someone a murderer is an opinion. Yeah. At that point, one can still call him a murderer, just not a convicted murderer. He has no case. Now, I think this is generally speaking true, and I have said this before. Now, I don't think he has a case for the specific things that were highlighted here. I don't think he has a case for Whoopi Goldberg calling him a murderer, even after the acquittal. I don't think he has a case for Cenk Uygur calling him a murderer, even after the acquittal. And I've pointed out before that this, to my mind, is a very different fact pattern from the Covington Catholic kids. To my mind, the issues that face those 2 groups of people are very distinctly different. And I don't think that just because the Covington Catholic kids were successful in their lawsuits necessarily can be made to understood that Kyle Rittenhouse will be successful in his lawsuits. I'm skeptical going in to any particular lawsuits. Now, if any lawsuits, of course, get filed by Rittenhouse, I, of course, will cover them. And if there's something in there that has some teeth, I'll, of course, let you know. But I'm just trying to be honest from my own vantage point going into this thing. The problem is that before the acquittal, this is a matter of public concern. And even after the acquittal, it's a matter of public concern. It's hard to get much more matter of public concern than, a murder that occurs. That's pretty matter of public concern. And then, of course, after the whole trial, Kyle Rittenhouse has quite prominently injected himself into national media by appearing on national news programs. So he's a public figure. So obviously the heightened standard of defamation applies. And I think you're going to have a problem proving things that were defamatory. Now, if his mother wants to sue for defamation, or other members of his family want to sue for defamation, I think they have a more interesting case. For example, if his mother wanted to sue for saying that when the media said that she drove him across state lines with an AR-15, I think she has a much more interesting case than Kyle does. But my initial impression going into this is my skepticism is against Kyle. That's not because I don't support Kyle or wish that he would win. But in my view of the law, I don't think it can support him winning based on the overall tenor of what's going on. Again, this may not be true in the specific. I'm talking about in the general. In the general, I don't see it. In the specific, he might have a specific case. But we'll only be able to see that when it comes, if it ever comes in a specific lawsuit. But my overall sentiment to people is to be cautious and not necessarily think that will necessarily result in a huge win for Kyle Rittenhouse, because I don't particularly see it at this time based on my overall impression of the situation at hand. Okay, let's move on to story number 2. This is going to be a follow-up from a prior story. The LA DA has backtracked somewhat late in the day, a little bit too late to do anyone good, after sentencing a 26-year-old transgender person who likes to roughhouse with the youngins in a way that is not socially appropriate to 2 years in a juvenile facility. Sentenced the 26-year-old for transgender, for the roughhousing with the children, to 2 years in juvie court. The 26-year-old. Okay, and the DA is having some second thoughts about this, apparently. Okay. Los Angeles County District Attorney George Gascon. No one's a douchebag like Gaston. No one sucks like Gaston. No one is a bastard like Gaston. Acknowledges on Sunday that he may not have properly handled the case of Hannah Tubbs, a 26-year-old transgender woman, that's a man baby, who was sentenced to just 2 years in a juvenile facility for the prurient, forcible assault of a 10-year-old. A 10-year-old. The 10-year-old was assaulted and by a person who was at the time just under the age of 18. Incidentally, it took 8 years for this to come to justice. 8 years. But at the time, it was a 10-year-old, and transgender heroine over here was just before her 18th birthday. And what do you get for the touching times of the 10-year-olds? How about 2 years in juvenile? But I'm sure it's her first offense, right? While for most people, several years of jail time is adequate, it may not be for Ms. Tubbs, the progressive DA said in a statement. After her sentencing of this case, I became aware of extremely troubling statements she made about her case, the resolution of it, and the young girl that she harmed. Why are you becoming only aware about this now? Fox News obtained jailhouse recordings of Tubbs speaking with Tubbs' father, in which the convicted transgender touching of the children person laughed about lack of consequences for the crime. The conversation of this jailhouse recording also includes explicit remarks about the victim that are unfit to print. Not seeing a lot of remorse here by our friend. I'm going to plead guilty, Tubbs said in one recording. They're going to stick me on probation and it's going to be dropped. I won't have to register, won't have to do nothing. Tubbs was arrested nearly 8 years after perpetrating the crime and later began identifying as a woman. The district attorney told Sia Shanna told New York Post that Gascon over here has long been aware of the jailhouse recordings despite his comments on Sunday. The DA never contacted him, though he was lead prosecutor. The prosecutor was in possession of all the evidence and knew or should have known of every statement made by Tubbs when he believed Tubbs should be tried as a juvenile. Gascon knew about all 250 plus jailhouse tapes and removed him from the case the night before the hearing when I was going to play the tapes. And also, this person will surprise absolutely no one. This is not their only incident with the touching of the underage children. This is not their first offense. But, you know, they're openly mocking the criminal justice system on tape. And after conviction, openly mocking the conviction that they got for the 2 years. So, and the DA, Gascon over here, is having some second thoughts about the whole thing. Way to go, Los Angeles, on all that. Way to go, all that. Let's talk about another assault involving another child in a different place. Let's go from California to Virginia. Let's talk about a different one, because there was another one that was just recently resolved. And this one was one that gained some huge national attention in Loudoun County. I used to live very near Loudoun County. I used to live pretty much next door to Loudoun County. So I'm very familiar with Loudoun County, which incidentally, unrelated to the story completely, has some very good wineries. It also has some other things that are not so great, apparently. A judge has sentenced a Loudoun offender teen for an assault in a bathroom. An assault in a bathroom from a transgender person. As memory serves, the one that we just covered, the one in California, was also in a bathroom, incidentally. It was a bathroom of a Denny's, not this story. The one we just covered, the one in California, where the just under 18-year-old assaulted the 10-year-old. Apparently that happened in the bathroom of a Denny's. This one happened in the bathroom of a school. But there are no issues with transgender people accessing bathrooms of their choice. Pressing on. A Northern Virginia teenager found guilty of the assault, the prurient assault, of 2 female classmates at separate high schools, was ordered Wednesday to attend a locked residential treatment facility until they turned 15. The 15-year-old boy was also ordered to be placed on the sex offender registry for life at the hearing, which I suppose is one kind of a just result. A step the judge said she never previously ordered in a juvenile case. Too bad we apparently didn't get that resolution in California for the 26-year-old, who apparently was not added to any offender registry. The judge said that they felt compelled to do so after viewing the evaluations of the conduct after they were found guilty of assault. Yours scares me, she said of the report. I don't know how else to put it. They scare me for yourself. They scare me for your family. They scare me for society. Young man, you need a lot of help. The judge's decision to send the boy to a residential treatment facility rather than juvenile jail came after both victims and family said the boy wanted to get help, said they wanted the boy to get help. The judge called the gesture by the families very brave and generous. It is very generous. It is very generous for the victims to want that result. So if they want that result, you know, maybe some good of this will somehow come in this world yet. One can only hope, man, right? Before he was sentenced, the boy apologized to the girls and families. He said he didn't realize how he hurt them until he heard the statements. I'll never hurt anyone like that again. Not 100% sold on that proposition, but okay. As CBN News reported, parents were outraged after finding out the boy was involved in multiple assaults. After the first one occurred in a school bathroom at Stonebridge High School in May 2021, the boy was allowed to shift over to nearby Broad Run High School while he awaited trial in juvenile court. The second assault occurred in a Broad Run classroom last October, while he was awaiting trial for the first assault. Before the attack at Stonebridge, the teenager, who was 14 at the time, entered the girls' bathroom wearing a skirt. Despite making claims to the contrary, because, your teachers will lie to you about what's really going on in schools, the Loudoun County Superintendent Scott Ziegler was previously informed about the alleged sexual assault that took place at the high school bathroom. Ziegler, the school superintendent, sent out an email on May the 28th, informing the school board of an incident that occurred. In the message he wrote, "This afternoon, a female alleged that a male student sexually assaulted her in the bathroom." Then Ziegler said at a June 22nd board meeting there was no record of sexual assaults in the bathroom, but the May email kind of reflects that he was aware of it because he sent it in May, which precedes June. Several parents said that such a policy, The school board member, Beth Bartz, who has since resigned, asked Ziegler if there were any assaults that occurred regularly in bathrooms. And this is what the superintendent said, quote, "The predatory transgender student or person simply does not exist. We don't have any records of assaults occurring in our restrooms." The school superintendent says the predatory transgender student or person simply does not exist. I think we just read just now about the would-be 18-year-old assaulting the 10-year-old in the Denny's in that bathroom. But, this person doesn't exist. Okay, so, yeah, that's all kinds of dumb. That's going on with that story. Okay, there's some more stupid in the world. Jen Shaw, you may know from Real Housewives. You may also know her from United States of America versus Jen Shaw. Jen Shaw has been accused of being involved in a financial scam using phones, telemarketing. I think it was either a Ponzi scheme or a pyramid scheme. It was one of those. Either way. And being fairly involved in it. So basically being accused of some wire fraud and some other things. And given the indictment that we read, which we did on a prior stream, it seemed like, the U.S. attorney had some pretty good information. Also, Jen Shaw, you might remember from previous coverage, because she said she couldn't hear the Miranda warning because of her itchy eyes. Anywho, Jen Shaw has decided that she would like some information from her fellow defendants who are also represented by other attorneys. Because as I mentioned, this was part of kind of a somewhat, sophisticated scam. Quasi boiler room style, although maybe not quite at that scale, with a lot of different people. And so a lot of people are being, indicted, and a lot of these people have different attorneys. And Jen Shaw would like to get some information from her fellow defendants to help assist her in her case. Okay, so let's review this and see what Jen Shaw wants. All right, so apparently she sent this to a couple different people. So this is just one of them, one of like 3 or 4 of them that exist, because I'm not sure how many co-defendants she has or how many attorneys there are. There's a few, but here's just one representative sample. They're all the same in material, incidentally. I checked. I just picked one because why not? So this one is going to the attorney, Lisa Scolretti, Esquire. And we are trying to subpoena them to produce documents to the attorney. Okay. So then we ask what we want. We want a whole bunch of stuff, blah, blah, blah. Okay. Requested to provide. So then it goes through basically all the sort of definitions. Everything means kind of what you would think it means, but of course in a subpoena, you have to lay it all out. Then it provides general instructions of how I want you to actually comply with it, and so forth and so on. And this is all standardized stuff, right? So we can skip all that stuff, right? The real meat of the stuff, the real meat of the thing matters when we get to the very, very end of it, where she says what she actually wants in this subpoena. What does she actually want? What are the documents that she wants from this attorney? Let's see if we can play spot the issue together. You get to play along at home. You get to play along at home. Jen Shaw has written a subpoena to an attorney, one of her co-defendants, okay? Can you spot the issue with these requests? Okay, here we go. Request number 1. All documents and communications between you, that would be the attorney, all documents and communications between you and any member of the United States Attorney's Office concerning this matter. I want the documents and communications that exist between you, the attorney, and the U.S. Attorney. All documents and communications between you, the attorney, and any law enforcement agent concerning the matter. All attorney notes or other documents prepared by you from each proffer session, which is basically like where you go to say what you're going to testify to. All attorney notes or other documents prepared by you from each proffer session, attended by William Sinclair, who is her client, in connection with this matter. Okay, kids, can you play spot the issue? What is the issue? What is the issue? Hi, I'd like all the documents that exist, attorney, that you yourself have created between you and the U.S. Attorney, you and law enforcement, and I also want to get copies of your notes and other documents you generated as a result of this proffer session that you and your client went to. Okay. For those of you saying privilege, you're basically correct. It's a slight variant of privilege called work product, attorney work product, right? Attorney work product. These documents you're asking me for were produced by me, the attorney, in the course of my official business dealings or my official representation of the client. So privilege protects any communications between me and my client. But all these documents that you're asking me for in these communications, you know what? You know the reason I was talking to the U.S. Attorney? Do you know the reason I was talking to the U.S. Attorney? You know the reason I was talking to law enforcement? You know the reason I was at this proffer session? It was attorney work client. So it's all work product. So you can't have any of those things. It's confidential. It's privileged. Okay. Now, there is a motion to quash and memorandum in support of this that I thought we would go over this, even though we just basically highlighted the issue and discussed the issue. I can summarize the entire argument and its conclusion in 3 words. Attorney work product. But let's have 12 pages of explanation on it so that we can go into a little bit more detail about this, so we can all learn a little bit more about the details about this, because details are always fun. And it's a good way to learn things here on Uncivil Law, which is how we roll. All right. Ms. Shaw is a charged defendant in this matter, alleged to have committed violations of federal law, such as wire fraud. Undersigned counsel, this is again one of the memorandums from one of the attorneys. And then the other attorneys basically said, yeah, and me too. So this isn't from the same attorney we just read. They all received the same thing. One of them decided to write it, and the other ones were like, yeah, just CC. Just whatever he said, right? They filed formal motions to final motions to join. So basically, this speaks for all of them, right? So you might see some different names, but same ideas, right? And you'll see, right? Undersigned counsel represents Kevin Hardin. He's pled guilty to several charges. It's possible Hardin may be called as a witness. On or about February the 8th, co-counsel for Ms. Shaw sent a process service to the office at Underside to serve a subpoena. While surprised, we immediately contacted Shaw's counsel and agreed to accept service via email subpoena as a professional courtesy. The subpoena demands production of, and you'll see this exact same thing, right? It's the exact same thing. All documents, communications between you and a member of the U.S. attorney, between you and law enforcement, between you and during the proffer session, in this case for Kevin Hardin. Same thing. Handren. Okay, so Ms. Shaw unilaterally selected a return date, which is very typical. Undersigned counsel spoke with counsel to discuss concerns about it and was advised they would seek enforcement of the subpoena absent comply. So they called them up and be like, no. Attorney work client privilege communications, no. And they're like, but we're going to enforce it if you don't. Okay. After receipt of the subpoena, we learned that several other lawyers have also received the same thing. We've seen this. And they're receiving verbatim requests, which we've also seen this. The subpoena issued by Ms. Shaw is a transparent effort both to intrude on attorney work product and impose undue burden on potential trial witnesses in advance of trial. Moreover, as Ms. Shaw's counsel, sophisticated and experienced criminal defense practitioners in this district, is well aware, the subpoena constitutes a premature and invalid end run of standard disclosures ordered by the court of the government. It should therefore be quashed. Yeah, because some of these things have to be given by the government when as part of Brady material, which incidentally, I'd like to once again remind just everyone, Brady applies to the government and the government's agents. Brady is the case that says you have to give over to the defense any evidence that would tend to show they didn't commit the crime, right? And there's case law to show that this duty applies not only to the prosecutor, but also to law enforcement. The prosecutor is responsible for getting it from law enforcement. Brady does not apply to other defendants and their counsels, because even if they're appointed by the government, as public defenders, they are not government actors within the meaning of this, right? They're not under the control of the prosecutor, as you can kind of tell from the term defense counsel. But certain of these statements would have to be turned over by the government as Brady material, which is fine. Get them from the government. There's rules for that. You can't get them from me, and you particularly can't get my notes of it. Okay, legal standard. Under the relevant rules, the statute invoked by Ms. Shaw for subpoena, Ms. Shaw bears the burden of showing the materials requested are relevant, specifically identifiable, admissible, and otherwise not procurable by exercise of due diligence. A defendant issuing a Rule 17 subpoena for attorney work product faces even greater burden, one would think. The highly sensitive and critical safeguards of work product for any client, let alone a criminal defendant, warrant vigilant protection from any improper intrusion. The Second Circuit has stated in a criminal case, except for scientific and medical reports, documents made by a defendant's attorney in connection with the case are not discoverable. But even if disclosure is permitted under some very narrow or fact-specific circumstances, at a minimum, the party issuing a subpoena must make an adequate showing of substantial need for document and inability to obtain its contents elsewhere without due hardship. Ms. Shaw cannot carry this burden. First, she seeks core attorney work product and cannot show either substantial need or inability to obtain it elsewhere, for example, from the U.S. attorney. Second, she seeks non-evidentiary and inadmissible material. Right, the attorney's notes and documents are not admissible. They're not evidence. Ms. Shaw may speculate some of the materials she seeks may be useful for impeachment, of whom, incidentally, because they're the attorney's work product. But impeachment material is not available through this rule. Not sure how that would theoretically work. Witness statements are unavailable through the rules, and in any state, such material would be inadmissible double hearsay because they're coming from the attorney's records of the conversation. Okay. Third, she seeks broad categories of material with insufficient specificity. Fourth, any material she seeks regarding representations or statements made by or the government or law enforcement can and will be obtained through discovery by the government. Right? That's where you would get that stuff. Talk to them. As noted above, Hardrin, like other clients subpoenaed for counsels who joined this motion, was a charged criminal defendant who may be called to testify at Ms. Shaw's upcoming trial. The subpoena seeks all attorney notes and other documents prepared by you, the counsel, for each proffer session, which is where you basically go to tell the government what you're planning on saying. It's part of the deal-making process. It's a protected meeting, a proffer session. They're very, very rule-based. You have to be careful. But if you do them right, you can kind of spill your guts a little bit, and the government can't use anything you say at that particular meeting against you. Right? So it's a meeting basically to say what you would testify to as a way of gaining the government's interest. That's what a proffer session is in this context. Right? Notes by counsel during this proffer session with the government are privileged as core product. I mean, of course they are. My client was there to tell the government all the things that they did as part of the plea deal, and all the things that they might have to offer as a potential witness against others. And I was taking notes about, what was being said and so forth in relation to my job duties as defense counsel. It's pretty core work product, because it's necessarily prepared in anticipation of litigation and reflects an attorney's opinions and mental impressions. The Second Circuit has suggested interview notes by counsel for a criminal defendant, like the proffer session here, are not discoverable. But even if work product privilege could hypothetically be pierced under some sort of unusual circumstance, like what would that be? There's no substantial need. Speculation the notes could contain impeaching material cannot help Shaw contain her burden. Yeah, no. To the extent Shaw deems any production by the government insufficient, assuming she has a good faith basis for believing so, she may press for additional production from the government at the appropriate time, which is not now. If Shaw seeks earlier production of the material, her recourse is to request reconsideration of the scheduling order, not to bypass the process. So in a criminal case, and not for in many cases, there's a scheduling order. Like, when will things happen? At what particular times? The time, excuse me as I get water out of my mechanical keyboard. The time for that turnover has not yet occurred. So it's a little bit early. Let's put the cap on that thing right there. At least I didn't get it on my computer, right? Independent of impropriety of seeking privileged work product in connection with the proffer session, the subpoena should be quashed because notes of any proffer session would contain double hearsay. Under Nixon, which Nixon is this? Is this Judge Nixon? Probably. Ms. Shaw has not articulated a rationale as to why she seeks information that's relevant, why the information she seeks is relevant or admissible. As a question of relevance, her one-size-fits-all approach in issuing identical subpoenas makes clear there's no specific theory of admissibility. As to the question of admissibility, her quest for attorney notes of proffer sessions also fails. To the extent the subpoena is trying to reveal a witness statement, it's improper under the plain language of the rule. No person may subpoena a statement of a witness or prospective witness under this rule. Rule 26.2 governs the production of statements. There's a separate rule for it, so you can't go into Rule 17. Since Shaw cannot seek a witness statement directly through Rule 17, she should instead seek the statement through counsel's interpretation or summary witness statements. But counsel notes about statements would be inadmissible double hearsay. And then it's in specific. It can be obtained at all, if at all, through the government, and blah, 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 so forth and so on. Yeah, so unsurprisingly to anybody, no, not so much with any of that. I am going to go get a towel to clean up the water, and then we will finish for the last story of the day, we will finish with a story of this United Airlines vax mandate, private mandate thing. And we will see whether or not, this makes logical sense. So just give me 1 minute. We will be in a very brief break and talk amongst yourselves. Okay, we're back. All right. So now we're going to read this vax mandate decision, which I'm kind of looking forward to because I want to see if it makes sense. It's 80 pages, so obviously we're going to skip around a lot. But so I'm basically going to be doing book briefing in my head on the fly, which, I can do because I've been doing this for a long time. But, if I'm skipping around, it's because kind of I'm reading things and deciding what does or does not apply to kind of issues I'm trying to get to, or issues that I think are interesting at least. So United Airlines had a vax mandate, and the district court denied the injunction. So saying to the workers, you can't have an injunction preventing them from doing this. And the Fifth Circuit has remanded it for further consideration. So I don't think they, strictly speaking, reversed. Well, they kind of reversed a little bit. We'll discuss this and see what happens anyways. And we're going to see if it makes logical sense, legal sense, right? That's one of the things we do on this channel, try to analyze the law. So let's do that. All right. Plaintiffs are United Airline employees. United has given them a choice: receive the COVID-19 vaccine or be placed on unpaid leave indefinitely. The question we address here is narrow. If United's policy is not preemptively enjoined, are plaintiffs likely to suffer irreparable harm? If that's the only issue you're trying to solve, then yes, I would think so. Yeah, if that's the only issue you're trying to solve, then, well, no, is it irreparable? Is it irreparable harm? Actually, I'd have to say no. And the reason why is there's one big thing that you always have to ask yourself when you're asking about irreparable harm. And the one big thing you have to ask yourself is, will money fix this problem? Right? Will money fix this problem? So is it irreparable harm? Well, let's see. If they're placed on unpaid leave, then they're not working. So they're not getting paid. But let's assume that somehow we come out the other end of all that, and we find out that that was a wrong thing to do. Can we fix that with money? Sure, no problem. We can look at if their salary, it's real easy, right? We just pay them for the time off. If they're some sort of hourly, we can compute it based on an average based on number of works, right? So the number one thing is, can money solve this problem? I'd be like, yeah, probably. So I'm not so sure about the irreparable harm, but we'll see. For the two plaintiffs who have received religious exemptions and remain on unpaid leave, we hold that they are. Okay. Critically, we do not decide whether United or any other entity may impose a vaccine mandate, nor do we decide whether plaintiffs are ultimately entitled to the preliminary injunction. The district court denied such an injunction on one narrow ground. We reverse on that narrow ground and remand. Okay. I mean, fine. So we all kind of know the facts, right? I mean, we don't have to read the exact facts and the exact timeline. It doesn't matter. We all kind of know the fact pattern. You know, they want to have a vaccine mandate. Do we care about the exact timeline? Not really. Okay, so they requested a religious or medical exemption. Plaintiffs filed an EEOC charge in September 2021, but because the policy would go into effect before they received right to sue, plaintiffs sued and moved for a preliminary injunction, alleging the policy violated Title VII of the Civil Rights Act and the Americans with Disability Act. Specifically asserted United's placed its religious and disability workers in an impossible position. Okay. After plaintiffs filed suit, United changed its policy to allow certain employees with non-customer facing operational roles the accommodation of working pursuant to masking and testing. United also permitted some customer service representatives to switch to remote positions. This allowed 3 of the plaintiffs to continue to be working paid, but for customer-facing employees, including pilots, indefinite unpaid leave remains the only accommodation. Okay. So, I mean, we've got injury, but is it irreparable? The question presented to us in this appeal is whether the district court erred by denying plaintiffs a preliminary injunction on the ground they have not demonstrated a likelihood of irreparable injury if United's policy continued to operate against them while their Title VII suit is pending. We hold the district court erred as to the plaintiffs who remain on unpaid leave and have brought their actions. Plaintiffs are being subjected to ongoing coercion based on their religious beliefs. That coercion is harmful and in and of itself cannot be remedied after the fact. I'm not sure I buy that either. Because the coercion obviously hasn't been successful because they haven't done it. And so, I'm not sure I buy that one. The decision to grant or deny a preliminary injunction lies within the sound discretion of trial court. The purpose of a preliminary injunction is to satisfy the status quo. Here is the 4-part test. You guys will remember the 4-part test. It's the same 4-part test we see in every TRO or preliminary injunction ever. They're all worded slightly differently because different circuits have adopted them slightly differently, even though the U.S. Supreme Court set it out. Nevertheless, the circuits still go with their individual tests, but it's okay because even despite this different wording, it's all the exact same thing anyway. But here's the Fifth Circuit, how they've said it. Preliminary injunction. You need the following things. A substantial likelihood of success, a substantial threat of irreparable injury. The threat and injury to the movement outweighs the threat and harm to the party seeking to be enjoined, and granting the relief will not disturb the public interest. We must address the broader issue of whether a preliminary injunction is ever available to plaintiffs suing private employers under Title VII. We hold it is. I mean, that makes sense. I would think so. Who's Mystic, Stephanie? Oh, I was just saying, yeah, everyone should listen to them. Help me like, comment, subscribe. Yeah, absolutely. Thank you very much. I appreciate that. Thank you, Mystic, for your nice encouragement as well. Nothing in our precedent forecloses the ability of a preliminary injunction for Title VII. Okay, yeah. In some case, we held that where an employee establishes both irreparable injury and likelihood of success, employee may bring their own suit to maintain status quo pending action of EEOC. I mean, that isn't necessarily a given, by the way, incidentally, because, well, let me just raise the issue, right? You have to ask the EEOC first before you can get a permission to sue. And whether or not they say yes or not, right? Because if they say no, you can't sue. That's because they don't think you have any kind of case. And you can still sue, but, then the EEOC is part of the record, and, it helps to filter out real crap. So you have to go ask the EEOC first before you can sue. That's for merits. So now we're talking about an injunction, which is not merits, right? We're talking about an equitable remedy in terms of an injunction remedy. So it's like, well, can you get that in the absence? We can talk about it later, Stephanie. Stephanie just messaged me and asked about something for modding, and we'll talk about it later. But just remember to stay broadly on topic of what we're talking about at the moment, or what stories we've covered. Please. Okay. Let's see, where were we? All right, so there's some prior case that says you can bring this to maintain the status quo, which makes sense. They may be entitled to a preliminary injunction until the EEOC decision if they can make the required showing. Okay. The Supreme Court has limited the ability of private parties to sue for injunctions in civil rights actions, but it didn't do so in cases like this. In the Supreme Court case, the Supreme Court held plaintiffs had no private right of action under Section 602 of Title VI of the Civil Rights Act. The court specifically noted, however, that plaintiffs can bring such suits under Section 601. The difference in the provisions is that while 601 specifically provides for private rights against discrimination, 602 only gives instruction to federal agencies. I mean, that makes sense, right? Section 703 of Title VII, like 601 of Title VI, provides for private rights against discrimination. Thus, Title VII plaintiffs have the benefit of Supreme Court holding in Cannon versus University of Chicago, where the court explained that when a remedy is necessary or at least helpful to accomplishment of a statutory purpose, the court is decidedly receptive to implication under a statute. I mean, that makes perfect logical sense in terms of our ability to ask the court for this remedy. All right, so the general rule established by statute and precedent is that before bringing a Title VII action in an Article III court, plaintiff must exhaust administrative remedies by filing a charge within the EEOC within 180 days of discriminatory action. This, incidentally, is just generally true for federal law in general, not necessarily state law, but in federal law, they require you to exhaust your administrative remedies before going to court, almost always. So this is very typical. The exhaustion remedy is qualified, which it could be in specific cases. This court has held in Title VII cases, an individual employee may bring suit to maintain status quo pending action of the EEOC on a basic charge of discrimination. Thus, although they didn't exhaust the remedies, they may seek the preliminary injunction. Okay, fair enough. That isn't necessarily a given, by the way, because as we've mentioned before, injunctions are an equitable remedy, not a legal remedy. So it's not something courts have to do, but apparently they said in the prior case law, it's something they can do in this kind of situation. United asserts Drew is inapplicable for two reasons. The plaintiff in the case purportedly had exhausted remedies, and the Supreme Court decision in Sandoval. We disagree on both points. It seems like a rational distinction between what the Supreme Court was saying. I tend to, this part of the analysis makes sense to me. Although the EEOC proceedings had concluded by the time this court issued the Drew decision, the plaintiff had not yet exhausted when it was filed. Yeah. Sandoval and Ross did not implicitly overrule Drew. In Sandoval, the court held that private individuals may not sue to enforce disparate impact regulations promulgated under Title VI, under Section 602. It's discussed, however, the court specifically recognized that individuals may sue under provisions of Title VI, which, unlike the provision at issue in that case, it has languages establishing a right against discrimination. Yeah, that seems right. So I think they're right as to that much. And then so fair enough. Continuing on. Now we address the central question presented, whether the district court erred by concluding the plaintiffs had not shown they will suffer irreparable harm without a preliminary injunction. This case is rather unique among Title VII cases. Plaintiffs allege a harm that's ongoing and cannot be remedied later, that they are being actively coerced to violate their religious convictions. Because that harm is irreparable, we reverse to the district court. The district court has held that plaintiffs have not demonstrated a likelihood of irreparable harm, or irreparable harm, depending on how you want to pronounce it, as they must do to be entitled to a preliminary injunction. As for harms resulting from being placed on unpaid leave, like lost pay, loss of skill and seniority, stigmatic injury, and marital strain, the district court noted such injuries are too speculative or could be remedied. I would think. As for plaintiffs' assertions that they're being harmed by being coerced into a choice between their religious convictions and continued employment, the district court concluded that plaintiffs could not assert such a harm because while they might be cognizable in a First Amendment case brought against a government entity, it is not cognizable harm in a Title VII case brought against a private entity. Okay. So the district court concluded that while that harm would be cognizable against the government, which makes total logical sense, right? If the government's trying to coerce you, there's a First Amendment problem. So that, but not cognizable in Title VII. Okay. In lawsuits alleging wrongful termination or adverse employment action, the plaintiff is not normally irreparably harmed. This is because the statutory relief available at the conclusion of the lawsuit, including reinstatement and back pay, can adequately compensate the plaintiff for the wrongful conduct. As the Supreme Court has explained, mere injuries, however substantial, in terms of money, time, and energy necessarily expended, is not enough. Our cases recognize two different categories of harm in employment cases. The first and by far most common harm is adverse employment action itself. Sampson addressed that category. A Title VII plaintiff is obviously injured by an adverse employment action, and the adverse action can turn to all sorts of other harms. But under Sampson, none of these harms can support a preliminary injunction. After all, the entire point of Title VII's remedial scheme is to return the employee to status quo and then compensate them for all damages that result from the action. So the mere bringing of the thing itself is not enough harm because the title itself says how to deal with that. Right? That's the entire point of the title. You can't say that the Title VII injury is enough harm for me to get remedy under equity because the Title VII law itself provides for the remedies. So you have a legal remedy. So, yeah, that makes sense. Our decision in Morgan versus Fletcher illustrates the first time of harm. In that case, an employee allegedly suffered discrimination and attempted to get injunction to prevent termination. We held an employee failed to show irreparable harm because the injury stemmed exclusively from the employer's decision to terminate. It therefore did not matter if plaintiff's salary represented 45% of her income, that losing it would likely result in foreclosure of the home, and losing medical benefits could alter her mental health. Such harms resulted only from the decision to fire her, and that decision alone cannot support the injunction because Title VII itself says what the remedies are, right? You make them whole. You give them the money back. The second category of harm recognized in our case law includes injuries that are independent from the adverse action. Very few employment suits involve such harms. That is so because in most Title VII cases, adverse action has occurred and it is the basis of the suit. And under Sampson and Morgan, any harm that caused by the adverse action itself is compensatable, if at all, only at the end of the suit. Neither can a plaintiff show independent harm by pointing to the strength of their case. That just goes to likelihood of success, which isn't enough. The rationale for the principal result recognized in White is simple. If plaintiff has a strong case on the merits, she's likely to win her suit and get compensated with Title VII remedies. But the fact that such independent harms are rare does not mean that they don't exist. To the contrary, both Sampson and White explicitly recognize that plaintiffs can sometimes, even if rarely, establish independent harm separate and apart from their underlying claims. Plaintiffs in this case alleged precisely the sort of extraneous and irreparable harm that those cases envision. Crucially, plaintiffs are not seeking an injunction, merely to prevent an adverse employment action or any harm seeking from that action. Indeed, plaintiffs admit that prior case law would preclude injunctive relief if United simply fired them. The allegation of irreparable harm based on coercion is antecedent to, independent from, and extraneous to any adverse employment action. Plaintiffs specifically allege that United wants to coerce them into getting a vaccine that violates their sincerely held religious beliefs and thus avoid any adverse action. Properly understood, the plaintiffs are alleging two distinct harms, one of which is repairable and the other which is irreparable. The first is United's decision to place them on indefinite leave. That harm and any harm that flows from it can be remedied through back pay, reinstatement, or otherwise. The second form of harm flows from United's decision to coerce them into violating their religious convictions. I'm not sure I buy this rationale, especially if we concede that simply firing them would not have triggered this problem. Because we've conceded that. Because apparently the case law requires that concession. So if United had simply fired them, get the vaccine or get fired, but because they put them on leave, so the coercion's ongoing? I don't know, man. I'm not sold. This court and the Supreme Court have held the loss of First Amendment freedoms for a minimal period of times unquestionably constitute an irreparable injury. Yeah, if it's the government doing it, for sure. Indeed, we've recently held that plaintiffs suffered irreparable harm from being coerced into a choice between their jobs and jabs, or between their beliefs and benefits. In each of these cases, the plaintiff brought actions against the government or government officials, so the First Amendment applied. Well, yes, if it's the government, then we're in an entirely different ball picture. Yeah, I have no problem if we're we're talking about the government, because yeah, that's a totally different thing, or at least in my mind. Plaintiffs here brought a statutory action against Title VII. Certainly when a court considers where a plaintiff is likely to succeed on the merits, it must consider both the provision the action is brought under and the identity of the defense, among other things. But here we consider only whether the plaintiffs are likely to suffer irreparable harm. The answer to that question depends simply on the effect of defense action on plaintiffs. In other words, we do not agree the fact that this is statutory action instead of action filed under the First Amendment meaningfully transfers what a plaintiff must show to demonstrate irreparable injury. I'm not convicted. I'm not sold by that. Levy Linville says it's constructive dismissal. Yes. Yes. The problem here, Levy, is that if they had outright fired them, we wouldn't have this argument. That's constructive dismissal is, I don't disagree with you, that's constructive dismissal, but it's kind of for that reason that it's constructive dismissal that I'm kind of coming to these conclusions. Because the case law seems to support, according to the Fifth Circuit's own analysis, the case law seems to support that if they were just outright fired, then they couldn't get this relief. There wouldn't be anything to enjoin because they've already been fired. Injunctions maintain the status quo. And so any relief you would get would be after the fact, right? So if they were fired flat out and it was a violation of law, then you wouldn't be able to get an injunction. What you would be able to get is damages at the end of the case, such as back pay and reinstatement, or other things that you missed along the way. Seniority, for example, we could order that. We could order remedies. So I have no particular problem saying that this is constructive dismissal, but the very fact it's constructive dismissal kind of seems to suggest the opposite result legally. So yeah, that's kind of where I'm breaking down a little bit here in terms of the legal analysis. Being placed on unpaid leave would defy severance and unemployment unattainable. The nature of the unemployed, they wouldn't be able to get unemployment because it would be a for cause firing. So I'm not sure that even I'm not sure that there's, yeah. And even if that's true, it's still money because unemployment is money, right? It's all money that can be fixed. It can be fixed with money, right? If you're entitled to unemployment and you don't get it, we can fix that with money. At least that's the legal conceit. We explained under both the constitutional and statutory provisions, the plaintiff demonstrates irreparable injury by alleging harm, freedom of their rights. It is true that RLUIPA is construed in favor of broad protection of religious exercise to the maximum extent permitted by terms of its chapter and constitution. And Title VII does not contain specific language, but Title VII does prohibit discrimination by any employer against an individual with respect to compensation because of religion. Indeed, although we do not address the matter squarely, this court has favorably quoted that proposition that through Title VII, Congress intended to protect the same rights in the private employment as the Constitution protects. Simply put, any dispute over whether actions ultimately violate Title VII is a question under likelihood of success. Here we're considering only whether the plaintiffs have shown irreparable harm. We believe they have. United has presented plaintiffs with two options: violate their religious convictions or lose all pay and benefits indefinitely. That is an impossible choice for plaintiffs who want to remain faithful but must put food on the table. In other words, United is actively coercing employees to abandon their convictions. Indeed, at a town hall meeting, United CEO revealed United's sentiments towards parties like the plaintiff. He noted very few religious exemptions would be granted, and he warned that any employee who all of a sudden, I'm really religious, would be putting her job on the line by requesting accommodation. Well, that's a problem. You shouldn't say that. Of course, even those who successfully requested religious exemption were deprived of all meaningful employment benefits by being paid indefinitely on indefinite unpaid leave. Thus, plaintiffs are continually subjected to the coercive choice. United complains this concept of irreparable harm gets things backwards. It simply could have fired all its unvaccinated employees, and then they would have no basis to seek an injunction. But because what United took, it labels a more accommodating approach of them giving a time frame with which they could get vaccinated and keep their jobs, it is now subject to preliminary injunction. United argues it's illogical that seeking to accommodate its employers renders it subject to an injunction. I mean, I'm kind of with United because the remedy here is, okay, you're fired. That's the remedy for United. Okay, you're fired. Now there's no more injunction. United's argument has some intuitive appeal, but it mischaracterizes both United's conduct and plaintiff's injuries. United labels its approach accommodation, comparing it to simply terminating unvaccinated employees, but the content of the accommodation for customer-facing employees merely gives them time to consider whether to acquiesce to dimes rather than indefinitely lose pay. United argues such treatment is better than simply firing the employees because it gives them a choice they would not otherwise have. But not all choices are received as an advantage. Plans asserts the choice United has given them has created a crisis of conscience, pressuring them to abandon their religious commitment. By threatening termination, United has enlisted employees and their families in the project of reforming employees' religious commitments. Putting employees to this coercive choice imposes distinct and irreparable harms. I mean, the thing for United to do here is simply fire them. Just fire them. End of problem. Right? We are removing the coercion. You're fired. You're done. You're no longer welcome at United. And you're done. So I don't think I buy this rationale. Joshua says the company would never fire the employee until the government told them to. I mean, the employer is a private actor. They can fire people or not. Whether or not it's legal or not, I don't know. But No Zuka says, I love you, man, but have some pretty bad takes. They were not fired. I mean, yes, I know they weren't fired. I mean, I'm not confused. But they could have been, and they can be. So I'm not quite buying this rationale. It doesn't quite work for me. Well, maybe it's just a difference of opinion. I just don't quite see it on this one. Now, how do I get my mouse to stop doing that? Stop making the thing bigger. Just make it scroll. How do you get a scroll wheel to start working again? Damn it. There we go. So we reverse and remand for further discussion. Dissent from Jerry Smith. In its alacrity to play CEO of a multinational corporation, the majority shatters every dish in a China shop. It rewrites Title VII to create a new cause of action. It twists the record to fit that invention. It defies our precedent and commands the Supreme Court. But the majority is no senseless bull. Knowing exactly what it wrought, the majority declares its unsigned writing will apply to these parties only. By stripping the judgment of precedential effect. Did they do that, really? Hold on. Okay. So yeah, there's an asterisk that I missed in a footnote. The court has determined this opinion should not be published and is not precedent. That feels wrong. That feels wrong. Now, the reason you don't publish a decision, or the reason you say something is non-precedential, is because it's just routine application of prior cases, right? So when they say published, they mean literally published in the books, in the physical books, right? And there's too many cases to publish. So it's not unusual to say a case shouldn't be published. But to say that a case is not precedent is basically to say that this is just routine, ordinary, normal application of facts. And I don't think it is. So I think the majorities here is, I kind of with the dissent on this one. It's like this to say this is non-precedential. I mean, that seems wrong. I mean, if you really think this is correct, make it precedential. But you're saying it's non-precedential. That's weird, man. I don't know. I don't know. For every conceivable reason the plaintiff should lose this appeal, the statute does not allow the relief they seek. Nor do our precedents. If they did, the Supreme Court's overruled them. If they've not been overruled, 50 years of precedence and century of Anglo-American remedies show that the preliminary issue may not issue. If it could issue, it shouldn't, because only plaintiffs withstanding claim no harm from the impossible choice. The only plaintiffs withstanding claim no harm from the impossible choice between full judgment relief and eternal damnation. If we accept plaintiffs' theory and twist the facts to support it, we must dismiss the appeal because plaintiffs have not exhausted their remedies. If we excuse that, they do not answer United's defenses, so they're not shown they're likely to win. And if they have shown, the equities and public interest would preclude an injunction. Well, I don't agree with all those reasons. I don't agree with all those reasons from the dissent. But I do agree with some of them, which is enough for me to be in the dissent. Instead of confronting these odds, the majority ignores them and invites a new Title VII sin called ongoing coercion, resulting in the plaintiff's win. Although alleging ongoing coercion now supplies a private right to a preliminary injunction. Not because of text, history, or precedent, because two well-intentioned but misguided judges say so. My distinguished college colleagues claim themselves as faithful textualists. They accurately apply statutory text and case law to controversy. I dispute that and show why. Yeah, I think that, yeah. So a little bit of history about the history of COVID and some things in terms of the measures. A little bit of the history of the blah, blah, blah. Okay, the sole issue on this interlocutory appeal, because we're in the middle of a trial, is whether the district court correctly denied them the preliminary injunction. The plaintiffs asked the district court to stop United from placing them on unpaid leave. The court declined because plaintiff had not shown irreparable harm. The same four-part standard we all know and love. The majority reverses the district court as the plaintiff and flight attendant. The majority concedes that all their injuries are repairable but one, the impossible choice between vaccinating and seeking full post-injunctive relief. To reach this result, the majority invents a new cause of action for employees who allege an ongoing coercion. The majority says that such employees may seek preliminary injunction even without exhausting their administrative remedies as Title VII requires. Moreover, we must presume their irreparable harm no matter what the record shows. The plaintiffs must answer three questions. The first is whether federal law entitles them to seek preliminary injunction. It does not. But if it did, the second is whether the plaintiff's impossible choice is an irreparable injury. It is not. But if it were, the third injury is whether we may affirm a denial of injunctive relief on other grounds. We may for at least four reasons. One, they've not exhausted their administrative remedies, which I'm not sure is technically required. Two, even if we could excuse that, they've not shown they're likely to win. But that's not the ground on which the district court based its decision, or at least one of them that they didn't. Three, even if they had shown that injunction would harm United more than would help plaintiffs. Four, an injunction would be a disservice to the public interest. Title VII explains whom it empowers to seek preliminary injunctions. Whenever a charge is filed with the commission, a commission concludes on the basis of a preliminary investigation that prompt judicial action is necessary to carry out the purposes of this title, the commission or the attorney general, in a case involving the government, governmental agency, or political subdivision, may bring action for appropriate temporary or preliminary relief pending final disposition. Thus, in cases involving the government, the attorney general may seek relief. In other cases, only the EEOC can do you. As any law student can tell you, expressio unius est exclusio alteris. Things that are not enumerated are excluded. When a statute grants power to certain listed entities, it does not grant the power to anyone else. That principle controls here. Because Title VII empowers the EEOC and Attorney General, it denies power to everyone else. I don't know if we're citing two different sections of the same statute or something. So I'm not going to offer a firm opinion as to dissent or not, as to which one of them is right here. So I'm going to demur as to which of them is better on terms of the statutory right or the equitable right to bring the case. So the dissent reads Sandoval differently. Sandoval held that private rights of action must be created by Congress. I agree with that. The majority says it does in Section 601. And then you cited some other provision of the law. Am I going to have to go start Googling statutes now to figure out which of you is right? Fine. Fine. Let's do some quick legal research with uncivil law. So uncivil law can figure out whether the dissent or the majority is better on terms of, is there a private right of action here or not? Talk amongst yourselves. Oh, Lord. All right, so 601. Oh, Lord, this is going to take a second. All right, so I'm on page 31 of this thing. Now I have to go back to the majority opinion and see what they cited on this, as I do legal analysis in real time, trying to determine who is right in terms of whether or not Congress is given a private cause of action on this. All right. Such section under section 601. Okay, section 601 of Title... Okay, no, wait, because that's Title 6. Okay, so I'm in the entire wrong thing. All right, so I'm in the entire wrong thing. All right, so they say it's in 42 USC 2000 E2 is where it exists. All right, 42 USC 2000 E2. All right, E-2, incidentally. And the dissent is citing E-5F2. Okay. Now, is there a way for me to easily share my screen as I go read a statute? Yes, probably. Hold on. Let's see. Need a new window. So we can do statutory interpretation with uncivil law. This is what you guys come for, right? You come for the deep dive legal analysis as I endeavor to try to get it right. As I endeavor to try to get it right. Okay, here's Title 7 of the Civil Rights Act of 1964, everyone. All right, so the majority cites E1. It was E1 what? E-1. And they are citing E-2. All right, so E-2. Is that an entirely different thing than Section E? It probably is. I hate it when they do these like partial numbering things in the statutes and then I get really confused. What is E-2? 42 U.S.C. 2000 E-2, unlawful employment practices. They cite the entire thing. You've got to be kidding me. You didn't give me a pin site? I hate you, majority. I hate you deep. I hate you deep inside right now. I hate you so deep inside right now because you didn't give me a pin site. Okay, fine. Let's see. Shall be unlawful for an employer. Okay. Shall be unlawful for an employer to fail to recognize. Shall be unlawful for a labor organization. Shall be unlawful for labor practice for any employer. Notwithstanding other provisions, shall not be lawful employment practice for employer to hire, blah, blah, blah. National security, seniority, and merit system shall not be unlawful for employer to apply different standards based on merit, perfect any business Indian reservations, interpret to require any management, labor organization, or joint committee subject burden of proof in disparate impact cases, notwithstanding other provision, prohibition on distribution test scores, resolution of challenges to employer practices, employee practice may not be challenged under circumstances. Oh, good Christ. So the majority just cites E2 generally. Does it... So there's nothing in E2 that provides a private right of action. Where is the majority coming up with a private right of action in this language? It doesn't say. Section 703 of Title VI, like 601 of Title VII, provides for discrimination. Section 703 of Title VI. I guess I could go back to the original Title VI and see if in Section 703 if it makes any difference in terms of language. All right, so let me go dig up the original Title VII. Can I get the original Title VII, please? As passed by Congress. I hate it, incidentally, when courts or practitioners cite things based on their original section numbers, instead of where it's codified in the U.S. Code, like a normal person would. Right? Why wouldn't you just cite the U.S. Code? But they do this in trademark law, for example, all the time. It would be very weird for a practitioner, except me. I do it because I don't think the other way makes any sense. But most practitioners don't cite Title 15 of the U.S. Code, section whatever it is. They cite section something of the Lanham Act, even though that's now in the U.S. Code. So I don't like it when they do that. All right, so here's section 701. 703. 703 is the exact same language we just read. I'll even show you because I'm just that dedicated here, right? Here's the exact same thing again. Now it's section 703 of the Civil Rights Act, which was later codified as 42 USC 2000E-1. And you see the exact same language. It shall be unlawful for an employer to do any of these things, hire an employee, unlawful employment practices. It's the same exact same thing, right? It's the exact same thing. So the majority is wrong. The majority is wrong, and the majority is speaking some bullshit. Because the dissent is right. I was under the impression the majority was not speaking bullshit to me when they told me there was a private right of action under Title VII. I believed the majority when they told me there was a private right of action under Title VII. But there's not. At least not under that section of Title VII. There's not. I can read. It's not there. The majority lies. The majority's bad. Meanwhile, if we turn our attention to the dissent, which actually cites a provision of law, which is 2000E-5F2, so we go over to E5, which is an entirely different section of law. Who titles these things? Enforcement provisions. Enforcement provisions. The commission is empowered to prevent any person from engaging. Whenever a charge is filed by a person or member commission, blah, 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 state, local authority, time for filing charges, civil action by the commission, blah, 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 injunctions. If a court finds respondent, which means the employer, okay, if a court, but this still depends on who it is. The court may enjoin the respondent from it by doing this stuff, but then it goes on in F2. Whenever a charge is filed by the commission concludes that the commissioner or attorney general may bring the action. Yeah, so then the dissent goes with the expressio unius ulterius est exclusio ulterius, to say one is to exclude the other, and says, yeah, well, they give the power to the commission and to the attorney general, so therefore not to an individual. And I think the dissent is right. And I think the majority is full of it. I know that this disappoints many of you who want it, but that's, I think, the better legal analysis, right? And we're here for the right legal analysis, right? And I think the dissent has the better legal analysis. So, sorry for the diversion there. Sorry for the diversion and all. But the majority and the dissent were telling me two very radically different things. One was telling me that the private parties can do this. One was telling me they can't. I'm like, that's okay. Let's go check the actual law and see what it says. And yeah, wouldn't you know, the dissent's right? Is a private right of action implicit? No, it is not. Yeah, it is not implicit. And even if it was implicit, the dissent notes the U.S. Supreme Court has said contra, which has more credibility here at this point, the dissent does. Because the dissent notes that Sandoval is a case from the United States Supreme Court, 2001 case from the U.S. Supreme Court, in which the U.S. Supreme Court said that private rights of action must be created by Congress. The judicial role is limited in interpreting the statute Congress has passed to determine whether it displays an intent to create not just a private right, but also a private remedy. Yeah, so I mean, I think the dissent's right. Yeah, I think in Sandoval, I think that they have more credibility with me at this point. But they seem to say, yeah, you know, not only a private right by a private remedy. Yeah, a private right of action is not implied by it. No. No. So and I don't know where they're getting this from. There's that water again. I thought flavored water was a fad. 10 years later, apparently not. No, man, I get a little bit of Crystal Light, put it in with my water. It gives me a little bit of flavoring. It's great, man. No calorie, get a little bit of flavor. Tastes vaguely like peach tea. I'm a happy man. Gotta like the flavored water. Put a little packet of flavoring in there. It's great. It gets me to drink more water. So there's that. The majority takes pains to stress plaintiff's injury is unique. That's why the majority claims the circumstances never occurred before in the history of man, and while recognizing it will not flood the courts with similar suits. That's all wrong, of course. Majority does not and could not offer such assurances about the resurrection of Drew and cabining of Sandoval. I could, in fact, also just squeeze lemon into my water. That is also an option. Thank you for noting that possibility. The decades-long shift from cases like Drew and towards like Sandoval was a triumphant of textualism and judicial restraint. One might think the majority would approve, but that's beside the point. Under the majority's reading of Title VII, every private employer in Texas, Louisiana, and Mississippi now has a cause of every private employee now has cause of action to seek a preliminary injunction. That's not half the problem. With Sandoval recast as a mere reading of one section of Title VI, every other statute that acknowledges some right may now have remedies. It's difficult to imagine what creative lawyers, not to mention federal judge spurned on by zealous law clerks, will do with these new tools. Yeah, I mean, yeah. All right, suppose all that's wrong. For the purpose of purely academic exercise, let's pretend Drew permits private plaintiffs to obtain preliminary relief despite decades of contrary binding precedent. Even there, we must affirm because they've not proved irreparable harm. Decades of precedent are clear. Preliminary injunctive relief is unavailable when there's an adequate remedy at law. That principle resolves the case because Title VII entitles such plaintiffs to robust legal and equitable remedies. The choice between seeking those remedies and refusing United's accommodation is neither an impossible choice nor irreparable harm. And even if it were both, the innocent plaintiffs who have standing claim no harm from that crisis of conscience, as even the majority admits. Really? See ante at night and at note 15, note 14. What does note 14 say? Oh, United also argues that the impossible choice is not a choice at all because plaintiffs said that they will never get the COVID-19 vaccine. They cannot be coerced. But even if that's true now, it doesn't mean it will always be so. As plaintiffs point out, this policy has proven effective. The record contains affidavit of one United employee who opposed taking the vaccine on religious grounds, but nonetheless received it after saying, "I could not afford to lose my job." Wow. So standing just went to shit. Standing just went to crap. Because these particular plaintiffs say they're never going to get COVID-19. So the coercion is meaningless to them. So it's not harmful to them. So they don't have harm from the coercion. Because they will never take it ever by their own admission. So they have no harm from the coercion. So the coercion is not a harm. So it's not a proper basis for relief. Bad take. What do you want? What do you want from me, contrarian? I mean, whether or not something is harmful to someone is up to them to decide, not up to you. And they apparently say that they cannot be coerced, so therefore it is not a harm to them. They say that they will never get the vaccine. So therefore, there's no coercion from them. So therefore, it's not a harm to them. I mean, that's what they say. I mean, how's that a bad take? I can't decide for them what is and is not harmful. They're deciding what's for them is and is not harmful. They say it's not harmful, apparently. How's that a bad take? I'm not speaking to everyone in the world. I'm speaking to these people and their causes of action in this legal analysis. Okay. The post-Sandoval court waxes scholastic about the far-off time when existence of statutory rights implied the existence of remedy. Judicial invention is dead, yet the majority exhumes it to right one last blunder from its corpse. Sandoval does not apply, the majority declares, because Title VII contains rights-creating language. That reasoning defies Sandoval's holding that the text must create not just a private right, but also a private remedy. Correct. The text does create rights-creating language, correct. But it doesn't create a private right. We read the relevant text together. I mean, okay, so to conquer these facts, the majority erased decades of precedent requiring plaintiffs to plead out and prove irreparable injury. It then invents a new per se rule. To show irreparable harm, a Title VII in plaintiff need only allege ongoing coercion because of a protected characteristic. Find that rule in a statute or case law or law of any federal circuit you want, it's completely fabricated. Well, they certainly didn't cite anything for that proposition. Equitable relief is extraordinary. It's unavailable when there's adequate remedy at law. And every judge should know the classic remedy at law is awarded damages. That's been the law for centuries. It sure has. To be sure, the mere availability of damages does not justify denying equitable relief. Damages may not suffice where a plaintiff injury defies measurement, or where damages cannot redress it. For example, harms to real property, every plot of which is unique, often call for equitable remedies, while harms to personal property do not. For this reason, constitutional violations inflict irreparable harms. Dollars and cents cannot capture the damage the government inflicts when it deprives rights that exist to defend. But where a remedy of damage is available and adequate, equity has no role, even if that remedy is not available right away. Yeah. Exactly correct. That's exactly correct and undebatably correct. Our precedent makes this an easy case. Title VII supplies adequate remedies at law, and the plaintiff's claimed harm, the coercive effect of lost income, stems from temporary loss of income ultimately to be recovered, which is not irreparable. The plaintiffs have adequate remedy at law. Title VII confers enviable remedies. If plaintiffs win at trial, the district court may order back pay, reinstatement, or any other relief as it deems appropriate. The fact finder may also compensate future pecuniary loss, emotional pain, suffering, inconvenience, mental anguish, loss of enjoyment of life, and other non-pecuniary losses. Even punitive damages are available if the plaintiff proved United acted with malice or reckless indifference to their rights. And the court may award reasonable attorney fees, including expert fees, to the winning side. That sounds like a lot of remedies. The plaintiffs insist their case is extraordinary because the mounting hardship of lost pay may coerce them to breach their religious commitment, which would inflict irreparable harm. Each day, they say, the pressure to choose between a job and a jab grows heavier. But that gives away the store. At the bottom, plaintiffs claim that they might decline unpaid leave and take the vaccine because back pay, reinstatement, and other post-judgment remedies are unavailable during their suit. That means, though, the alleged coercion stems only from the temporary loss of income ultimately to be recovered. Yeah, that's the problem, right? If the reason they're going back is because they need the money, That's not sufficient reason. Because money is all, because this is one of the, perhaps a fiction of law, but it's a fiction of law nevertheless, right? It's like, I need the money now, but we can give you the money later with interest. And that's sufficient, including punitive damages and all the rest of it. And it's like, but I need the money now. So you're complaining about monetary loss, which is not an irreparable harm under law. It's just not. Our case law leaves no doubt the injury is repairable. Even the majority admits unpaid leave and any harm that flows from it are repairable. Yeah. If the plans persist, they may eventually win all the remedies they want. So for their case to be special, they have to show those remedies are unavailable, but they can't do that. They haven't shown United lacks funds to comply with an adverse judgment, or that recoupment will be impossible. Yeah. The majority concedes, as it must, that harms flowing from adverse employment actions are not irreparable, given that federal law supplies attractive post-judgment remedies, including back pay and reinstatement. But that creates a problem for the majority. It means that these plaintiffs who have alleged such harm cannot show irreparable injury. Because the impossible choice theory is a loser, the majority rewrites it. It insists the plaintiffs' alleged coercion injury distinct from United's offers of unpaid leave. The plaintiff's harm is irreparable, the majority contends, because it's antecedent to, independent from, and extraneous to any adverse action. Crucially, the majority explains, plaintiffs are not seeking an injunction to prevent any adverse employment action or harm stemming from it. They're not seeking merely to undo or prevent unpaid leave. Instead, the majority says, plaintiff specifically alleged United wants to coerce them into getting the vaccine that violates their religious beliefs and thus avoid any adverse employment action. None of this is true. The plaintiffs brought this action to stop United from placing them on unpaid leave because unpaid leave is an adverse employment action. That's the whole point of their suit. Yeah. The majority then tries a different tack. The key fact here, the majority thinks, is that United didn't just fire its objecting employees, it did something much worse. By accommodating them with unpaid leave, United enlisted employees and their families in the project of reforming employees' religious commitments. Putting employees to this coercive choice, the majority explains, imposes distinct and irreparable harm beyond lost pay, benefits, seniority, and other tangible and remediable losses. That harm, the majority says, is ongoing coercion because of protested characteristic. That passage, like the rest of the majority opinion, assumes the severity of United's perceived wrong proves plaintiffs' irreparable harm. By putting plaintiffs to the coercive choice between unpaid leave and vaccination, United discriminated against employees with respect to their compensation, terms, conditions, or privileges of employment because of religion. From that assertion of Title VII liability, the majority concludes that United irreparably harmed the plaintiffs. Our precedent forbids this mistake. White explained that there's no nexus between strength and nature of underlying claims and an element of irreparable harm. Right. Irreparable harm is a completely separate element from the strength of the case. Remember the 4 factors? We've gone over them a couple times, right? Likelihood of success of the merits is one of the 4 factors. Irreparable harm is different. But suppose everything I said, let's posit instead that we accept crisis of conscience resulting from adverse action may constitute irreparable injury despite decades of contrary precedent and bedrock principles. Even then, plaintiffs should lose, because the record does not show that they are likely to suffer harm. The majority admits this fact, but declares it irrelevant. Casting aside circuit precedent requires them to plead and prove irreparable harm. They invent this new per se rule. According to the majority, these plaintiffs will suffer irreparable harm without injunction because United is forcing them to adhere, between choosing to adhere to their faith and putting food on the table. The plaintiffs, the majority asserts, endure a crisis of conscience, but the record belies that conclusion. Neither plaintiff testified to facing a crisis of conscience or anything like that, so neither has shown that irreparable injury is likely in the absence of the injunction. Zambrano, the pilot, declined the vaccine because he believes it was developed with aborted fetal tissue. That's what he believes, by the way. Whether or not that's true, that's what he believes. I'm not saying it's true. I'm just noting that that's what he said. United accommodates Sembero with unpaid leave. In the affidavit, he stated his annual salary exceeds $350,000. He then explained the current situation has put a terrible stress on me and my family. If I cannot continue earning a paycheck, we will have to make difficult choices regarding college education of my 3 children, one of whom is currently in college, and my twins who will go to college soon. For my child currently in college, the loss of income source could put in jeopardy my ability to pay tuition. Money, money, money. Always something. Right? It's money. It's money. Additionally, there are many opportunities we could be pursuing as a family that I cannot afford if I lose my salary. In his live testimony, Sembero stressed about how loss of seniority would affect him. Seniority, he said, determines the lifestyle you have. It determines the house you're able to afford and the place you want to live in. It determines the schools your children will go to. It determines time off one has. It determines whether I'm going to be there for my kids or my children's events. It determines whether I have weekends off. Not once did he say or suggest he felt a crisis of conscience or pressure to abandon religious commitments. Instead, he noted the efforts on his lifestyle and on his ability to pay for tuition. Money, money, money. Right? It's all money. It's just money, which is not an irreparable injury by law. It's not an irreparable injury by law. If your problem is money, we can fix it with money. That's the legal conceit. It is a non-debatable proposition of law. Money is not an irreparable injury. And apparently in his testimony, what he's talking about is money. King Canada refused the vaccine for the same reason and received a like accommodation. A flight attendant, she earns 35% of her household's income. She said unpaid leave will require her family to change its daily financial decisions and threaten the ability to afford college tuition. She also testified to marital strain, personal stress, and fear of losing good friends at work, but no crisis of conscience. No matter the cost, she swore, I will never take this vaccine. The majority says these facts don't matter a whit. A non-party United employee testified he took the vaccine despite religious objections, the majority contends, so we can ignore that our plaintiffs say they will never get the vaccine. Even if that's true now, it will not always be so. This fortune cookie aphorism would find irreparable harm everywhere. Yeah, because who knows what the future might hold, right? Such is not the law. A plaintiff seeking preliminary relief must show irreparable harm is likely without it. And because the plaintiff is the one seeking the relief, the plaintiff must show that she will endure the harm if no injunction issues. Our plaintiffs have shown neither. That a non-party took the vaccine despite religious objection tells us nothing about the likelihood of harm to the plaintiffs. But even if relevant, the facts suggest at most only a remote chance of harm, which does not suffice. I mean, yeah, and then there's a little thing here about the whole thing about majority describes this rule as a natural outgrowth of First Amendment law. We've seen that. We've assumed irreparable harm when government violates constitutional rights. Because United coercion feels the same, the majority suggests we should assume irreparable harm here. The majority's illogic premise proceeds from a faulty premise. The effect of the action on the plaintiff is not the same in the constitutional cases because constitutional violations work a different harm. The government exists to protect and uphold the Constitution. When the government exceeds the consent of the government to denied rights, that betrayal is a unique, freestanding, and immeasurable injury, distinct from the rights results of the misconduct. It matters not that the injury to free exercise feels the same to the plaintiff. What matters that it is in fact different. Importantly, plaintiffs do not plead a constitutional injury. Unlike constitutional injuries, Title VII injuries are neither unique nor freestanding. Yes, because without Title VII, there wouldn't exist. It's in Title VII. Our plaintiff's cause of actions exists at the pleasure of Congress. It is not a foundation of our social compact. Nor is it the same measurement problem. There's no question how to make an employee whole for Title VII. When an employee violates Title VII, we need only decide how much compensation, back pay, reinstatement, seniority, whatever. This point exposes a bizarre consequence of majority position. The majority draws on constitutional law to justify its presumption. Constitutional harm is special, I've explained, because the government is the one that inflicts it. Yet we do not presume irreparable harm in Title VII cases against the government. When private parties who cannot violate the Constitution violate Title VII, we must presume irreparable harm because these violations feel like constitutional injuries. Yet we do not presume irreparable harm when the plaintiffs bring the same claims against the government. I mean, this dissent feels like a pretty thorough thrashing of the majority opinion to me. It feels like a pretty thorough thrashing of the majority opinion to me. So, I think the dissent is better on the law. I think the dissent is better on the law. All right. Yeah, so I know some people, by the way, here are disappointed with this conclusion and might disagree with this conclusion. I hope they disagree with me for fairly sound reasons, though. Not just because of what they want to hear, but, you know, I have to agree with the dissent that there's no private right of action in the clauses we mentioned. That I have to agree with the dissent that the Supreme Court, that, you know, especially as textualists, we look for what Congress said, and there's no private right of action. And I have to agree with them that, you know, this does not quite make sense. I think the dissent trashed the majority opinion. I think the majority kind of knows it because they made their own decision non-precedential. Because if this really was the right standard, right? Because this is what the dissent is saying, like if this would open the floodgates. But of course it won't open the floodgates because they made it non-precedential. So it's like they're embarrassed by their own decision or something. So, Anti-Commie says, sorry, brother, that one was rough. Thanks for going over it for us. Yeah, no problem. Right? I was a little bit dubious going in, and the majority said some things that I was like, okay, kind of, maybe. And I was like, yeah. And then reading this dissent, I'm like, wait a second. And then going into what the law says. Bob Johnson says, do you agree that women's soccer makes less money? No. Lone Star Medic says, I was wondering if the reason why both people said it was answering to questions but not to irreparable harm. Yeah. So was there any super chats today? Let me take a look at the back end and see if there were any super chats before we sign off. And I'll take a couple minutes asking your questions. The bot, by the way, has completely failed. Well, let me check to see if the bot has worked. Maybe the bot has been fixed. The bot has not been fixed. So just type at Uncivil Law if you have a question, and I'll go into the back end of YouTube and see if there's any super chats. And I'll spend a minute or two answering questions or trying to defend my analysis or whatever. There were quite a few super chats today. Thank you. Sledge and Wedge gave me $5 says, I watch on my phone and PS3 to give you twice the viewership. God bless you and all that you do. Thank you. Anti-Commie says, Prurient, love the face curse. Your face is priceless. $2 from Zafale. Uncivilians back to A. Oh, I think I fixed it. Yeah, I think I fixed it. Did I not? With the scrolling text, it's getting all the way down, right? Hell Pike gives me $5. Love you, Kurt, and thanks for everything you do here on the channel. $5 from Anti-Commie says, you look stressed, so I throw money at you like stripper to make you smile. Also, thanks for doing it live. You're welcome. Super Iron Bob gives me $5 US. Citing acts can be even more insidious if the act is made up of remove period at XYZ and insert the following sentence fragment. I'm not sure what any of that means, but okay. Thank you for the super chat. Anyway, I had a very good workout, by the way, in case anyone wants to know. Before it's streaming, I had a nice workout, and then I had a shower and a dinner, and it was all great. Super Iron Bob says, wasn't this originally filed when the OSHA mandate was still in effect? Probably. I don't know. Couldn't say. Well, technically speaking, the OSHA mandate never went into effect. But I know what you mean. All right, it doesn't seem like there's any real questions or any sort of discussion. I'll just scroll up and see if there's anything else. Doesn't look like it. Okay, not a lot for me today. All right, so I'll just sign off the stream. $5 for Contrarian 420. Tip for the house, even if we disagree. Thank you. If you like this stream, please remember to do all the YouTubey things. I would appreciate it. Like, comment, subscribe. I hope you do enjoy the parts where I go and try to actually deep dive into the actual law and actually try to do some legal research and stuff on top of that, where it's like, I hope you enjoy all that stuff. And I hope you enjoy where I try to puzzle through and think through the issues and try to really think through everything and try to come up with something that resembles a considered opinion. So I hope if that's your flavor of law, then I hope that you'll become a subscriber if you're not already. Please remember to subscribe. Please remember to hit the join button for 99 cents a month. You too can become an uncivilian. You get the little cool scales of justice icon by your name. And as you saw, as I was reading, you now get your name on screen as it's going on as a little member benefit. So that's cool, which will also appear in batch records, which is also cool. And I think I fixed it. So it's not just like A through D now. I think it's all the names. So all those good things. I'm going to sign off for now. Until later, my friends, I hope all is well. Cheers and goodbye.